Our next case is Spine Specialists of Michigan versus MemberSelect.
I'm not worried about getting COVID. I had it recently.
Good morning. This is a mini oral argument on the application. You both have 15 minutes. You have 2 minutes of a free fire zone, which you may waive. And if you would like to reserve time for rebuttal, we ask that you keep track of that time yourself.
May it please the court, Steve Hicks on behalf of the plaintiff appellant, Spine Specialists of Michigan. I will waive the free fire zone in the hopes that I will get some time for rebuttal. I very rarely do, so I'm going to waive the free fire, and I'm ready for questions if you have them. If I could just pick up on a couple of points that were raised. First of all, in this case, the court has basically asked the same question that is the second question in the Encompass case. Basically, whether the Court of Appeals correctly held that the one-year back tolling provision, 3145 sub 3, does not apply to claims for PIP benefits that accrued before the No Fault Act was amended. In this case, they held that it did not apply. In Encompass, they held the opposite. So that is the same issue. That's the only issue I'll address unless the court has other questions. With regard a factual clarification just on this case, because I think it's different from the Encompass case, there's no denial in this case. This is not a situation, it's not similar to Encompass in that a partial payment was made, EOBs were sent out, that sort of thing. There's not a formal denial here. And unfortunately, that is more common than you would believe, because frankly, there are some insurers that prefer to stick their head in the sand and see if they can wait out the one-year back rule. That happened quite frequently when DeVillers was the law. So that is a key factual distinction in this case, and I think it's instructive as to what Citizens Council was saying about how they handled claims. That may be the case. It's not always the case. The Court of Appeals in this case basically applied Andry in much the way that Justice Zara was suggesting. That basically Andry said it applies only prospectively, therefore every provision applies only prospectively. That's what the Court of Appeals did in this case. And they did that because the Court of Appeals in Andry had a very broad view of how the No Fault Act would work and did not work through the LaFontaine factors. This court did something very different in Andry and something much more limited in scope. This court did, as Brother Counsel for Encompass mentioned, focused on the cap provisions only that were at issue in that case and whether those could be applied to so-called legacy patients. So that's what was at issue in Andry. So Andry, I don't think can be read as simply as the Court of Appeals did. And granted, they did that because the Court of Appeals ruling in Andry was different. But now having this court's ruling in Andry, I think it's very clear that the court's holding was limited and did not address other provisions such as this tolling provision. Basically, all the Court of Appeals said in this case was there's nothing that says the legislative intent was to apply it retroactively, and therefore it's clearly manifested based on the text wording. Game over, we're done. And did not apply any of the LaFontaine factors, did not bother to go through them. I think that's a real problem in light of Andry and what this court said in Andry. So let me focus on the statutory provision at issue here, because it's very different than when we're talking about the fee schedules, or as I would call them, fee caps, because there are other cases out there that deal with caps. The provision at issue here, first of all, clarification. The one-year back rule is not the provision at issue here, as much as the other side will argue about what the one-year back rule does and what it means and whether it's substantive or not. The one-year back rule was not changed. It was moved down to sub 2. It used to all be one lengthy paragraph. They moved it down to sub 2, but then they also added sub 3, which is the tolling provision. That really is at issue in this case. Tolling is what we're talking about. Tolling of the one-year back rule, not simply the one-year back rule itself. That's important because, you know, the one-year back rule is a statutory defense to untimely PIP claims, whereas 3145.3, the tolling provision, that's just statutory tolling of a statutory defense. It's like another step removed
But why
from the discussion.
Why isn't sub 3, you know, the Buell factor saying, looking at whether or not the statute would create new obligations or duties with respect to transactions or considerations already passed? It's a tolling provision that requires now an insurer to issue a denial. And as you said earlier, a lot of them weren't, right, under DeVillers, and you had to file it within the 1 year. So why would we not look at the new sub 3 as creating a new obligation or duty on the insurer that didn't exist prior to?
Well, first of all, I take issue with whether it didn't exist before. Whether they did it or not is a different question. There was an obligation to do it. We do have a 30-day rule in the No Fault Act, and there are some teeth to that in that PIP benefits are overdue, interest starts calculating, and more importantly, you can come back and say, seek attorney fees because there's been an unreasonable delay. But I think I'd also like to point out that they've always had this duty. This is how they should treat their insureds. I argued a case a couple years ago, Griffin versus Trumbull, that dealt with issues of, you know, who has the responsibility to investigate for a higher priority insurer. And I told this court that, yeah, the plaintiff and the plaintiff attorney do have to use reasonable diligence to find a higher priority insurer. But I also tried to point out to this court in that case that insurers aren't without their own duties and responsibilities when they have a contract with someone or they have a statutory obligation. They have a duty of good faith and fair dealing. And when you look at Trumbull, Griffin versus Trumbull is a good example of that. This court basically found that it wasn't good enough for Trumbull to just sit back and wait it out. That wasn't enough. So I would say that duty has always existed at common law, and it's existed in the No Fault Act, even if there weren't necessarily the requirement that there be a formal denial because of what this court said in DeVillers. There still were the penalty interest, there still were the attorney fees. There's always been an obligation there. So I don't think it's a new obligation for them, or at least it shouldn't be. I mean, this should be the way you treat your insureds. They submit a claim, they should get an answer. And the fact that they can get away with not giving an answer is something that I think the legislature is trying to correct.
Can you address, like, what are we looking at if we were to hold in this case that, at least with respect to the claims at issue here and in Encompass, that the tolling actually does apply? Is that opening up years and years of claims, or is it sort of, I'm struggling with, aren't we sort of capped within like the 1 year?
Speaking specifically of the facts in spine specialist, no, not at all. Basically, we're litigating over a laminectomy surgery that was before the law changed, and then everything else was resolved. So that the case is done. And more importantly than that, as I said at the outset, in this case, there was no formal denial issued. I need to clarify that. They did eventually kick out a formal denial. I don't know why they did that, since their positions they didn't have to. I guess maybe they started to get worried about that attorney fee provision. But in any case, they can close that out. And the practical reality is insurers are acting differently because of the decision in Encompass primarily.
Well,
it's real easy for them to formally deny the claim.
Wouldn't it have to, this idea that like we're gonna, a decision that way would open all these claims.
It won't.
Isn't it really only if, it would only apply if those claims, like notice was given, the insured didn't deny it, and the plaintiff didn't file suit within a year, right? I mean,
Yeah.
they were under that obligation.
Yeah, they've got a remedy under the statute, and they have a defense on top of that. They can issue the formal denial, but let's not forget, they can also say, you didn't pursue it with reasonable diligence. It's a laches component that's in there as well. So it's kind of the double whammy for the plaintiff.
Would you address for me on the question of whether the one-year back rule is substantive? I know you discounted it, but there's federal courts that in diversity cases have interpreted and found it to be substantive. What do you make of those cases?
Yeah, the argument that I believe this was made in the amicus brief is that, or maybe it was in counsel's brief, that federal courts have applied it, therefore it has to be substantive Michigan law. I think that's an interesting argument, but they never said it. You know, they never said we are doing this because it's substantive. They never pointed to a Michigan case that said the one-year back rule is substantive. It's not like that question went over to the state courts and this court affirmed that it is substantive. And second of all, we are talking about tolling of the one-year back rule, not the one-year back rule itself. Now, the other side would say, yeah, but they've applied the tolling too, so they must think the tolling's substantive because they've applied it in federal court. I just don't know how much we can read into what the federal courts have decided to do and how they've decided to apply it when there hasn't been any analysis in the federal court or in the state court, for that matter, on the substantive nature of the one-year back rule provision. So I guess that would be my response. I think it's an interesting point, but I don't think I think it skirts the real issue here. And I think the real issue here is the one that Brother Counsel for Encompass pointed out, which is, you know, when you work through the Buell factors, I don't know how you come to the result that they would like to come to, because it's always been said that a statutory defense is a valuable right, but not a vested right. So even if the one-year back rule is substantive, but it's still a statutory defense. So I don't know how they fundamentally get around that problem. If I can just quickly answer, I wanted to address two things that Justice Kavanaugh mentioned. With regard to, you know, what is the operative event when the charge was incurred? Over and over, the other side will say, you look at when the expense was incurred, that's when it accrued. Here's all this case law talking about when things accrue. The thing I would point out is that every case they cite is a tort case. If you look at the accrual provisions under statutes, that, you know, they're basically talking about tort law. PIP is much different, as we learned in Andrew, certainly. There's a lot of different moving parts. There's when the policy was issued, there's when the accident happens, there's when the claim's submitted, there's when and whether the claim was denied, there's when the lawsuit was filed. So what is the focus for us here with tolling under subsection 3? The focus should be clearly on commencement of the action, because that is the operative event there. When it comes to the one-year back rule, you can make an argument that it's when it was incurred, and because 3110 tells us that's when we're going to consider it accrued. But that's really just the measuring stick. The operative event throughout the tolling provision is commencement of the action. That's the thing that gets you going. That's the thing that matters. If you don't do it right, you're out. So that's why I think you can make the argument that this is clearly on the text prospective application, because the event that matters is commencement of the lawsuit. So hopefully that answered that question. One other question that Justice Kavanaugh asked: is there a distinction between expired, so-called expired claims and claims like this case, where the claim was made right before it was made? Surgery's in April. May, it's submitted right at the beginning of May, and there was no denial until a year and a half later. And then the law changes on June 11th. So clearly nothing had expired in this case. That's also true and encompass. But, you know, potentially there are cases out there where that may be an issue. I don't think it makes any difference for the reason I just talked about, which is that the tolling provision, not the one-year back rule provision, the tolling of the one-year back rule provision, the only thing that was amended in this act is singularly focused on commencement of the action. That's what you need to be looking at. You may use that as a measuring stick in terms of when, well, actually, it's not even clear that you use when the loss was incurred as the measuring stick. If you look at mobile MRI, another unpublished case that was cited by the other side, in mobile, because the plaintiff lost, but in that case, they focused on when the payment was denied. I'm sorry. So that's not even clear what the measuring stick is. But what is absolutely clear from the text of 3145 sub 3 is commencement of the action is the operative event. And there I go.
So-
You used up all your time. Justice
Sorry,
Kavanaugh,
can I
may I
just
ask you one more
Ask
question?
one more question. So say there was a surgery or an expense incurred in June of 2017, and it was submitted and not paid and not denied, and no suit filed, right? So 1 year, it completely expired, right? 1 year.
Suit filed after the law changed.
Suit filed after the
Yeah.
law changed. If we hold that the tolling applies, does that revive a claim for that?
That claim would be a viable claim if this court found, and if the plaintiff could overcome the argument
Of reasonably.
of reasonable diligence. And I think that's a tough sell when you sit on a claim for 2 years. Certainly, the standard that my client was held to in Griffin was a higher standard than that in terms of pursuing. There were some on this court who felt that he should have filed a lawsuit immediately so that he could get subpoena power in that case. Now, the majority didn't agree with that, but this sort of falls somewhere in between, and so that's how I'd respond to that.
Thank you very much.
Thank you very much. No rebuttal again.
Let's see. Good morning, Your Honors. May it please the Court, Daniel Saylor appearing on behalf of the defendant appellee, MemberSelect Insurance. I think I'll jump in right where we were talking. You were discussing whether this is a substantive or procedural law, and this will also dovetail into whether this amendment is curative or remedial as well. First of all, I would suggest that the one-year back rule itself, I know no counsel would like to differentiate, yeah, but this is tolling. We're not talking about the one-year back rule itself. The one-year back rule itself, I would submit, is inherently substantive. And this court has made clear in a couple different cases that it is a substantive limitations on the amount that can be recovered by way of benefits in a no-fault case. It doesn't talk about when it is timely filed. We assume they've got a timely filed action. It substantively limits how much can be recovered by way of benefits in that case. So that is substantive. And I would suggest that it's virtually specious to suggest that, yeah, but the tolling provision, the new tolling amendment, is procedural because it changes, it alters, it clearly modifies the effect of the one-year back rule. It amends it. It is an amendment to the one-year back rule, plain and simple. And that, quite simply, is what the de Villers court made clear and why it had a problem with what the Lewis court did years back when it developed this tolling provision on the one-year back rule.
Well, what about Mr. Hicks' argument that, in fact, it didn't actually change the obligation of the insurer because the insurer had a duty and an obligation to pay or deny claims prior to the statutory amendment? Whether the 30 days,
Or moral
the other
obligation,
provisions of the No-Fault Act, they always had the duty to do that.
Well, but the effect of it is altered, and the court in Buell talks about, as you referred to, that that when a statute impairs vested rights or, quote, attaches a new disability with respect to transactions or considerations already passed, it imposes a new consequence on whether or not an insurance adjuster issues a clear denial, or, just how formal the denial was.
Well, but in Buell, you were talking about a statute that created, that altered the duty, right? That sort of was trying to go back and rewrite an obligation or a duty that existed, after it had already occurred. And how do you square that with the idea? I mean, because obviously a statutory is always going to change something, right? I mean, otherwise why are we even talking about this? But we have case law that says, even a substantive defense isn't a vested right. A change to a defense. Shouldn't we be looking at this more like a substantive? It may be substantive, it's a defense, but that it's not vested, that the legislature can give it and take it away.
Well, the reason I'm emphasizing that this is substantive is because, generally speaking, we know that generally speaking, a statute, a new amendment, is the general rule is it applies only prospectively. And one of the exceptions, but if it's just procedural and not substantive, maybe we can, depending on whether it applies to vested rights or not, or a valuable right or not. But that assumes that it's procedural, and I'm suggesting that it is an inherently substantive amendment. And as I was saying, that's why de Villers pointed out that the court in Lewis did not simply apply facts to the parties before them to apply an equitable estoppel to the parties. It went beyond that in a very legislative manner, declared that the one-year back rule in the statute would now have this extra component, it would be subject to this extra component. And so therefore the de Villers court said, we're not just overruling Lewis and having a difference of opinion, we're calling that court out on doing something that it had no authority to do. The statute was clear, the statute is the law, and there we are. If somebody wants to add a change to the one-year back rule, it has to be the legislature.
But
and now it has done that.
What substantive right did you have that changed, right? Like when this expense was incurred and submitted to you, or your client, obviously.
Sure.
Or submitted to the insurer, the right was to pay it or not pay it, right? Pay it or deny it under the statute. What changed is sort of the parentheses around which ones you can expect when a lawsuit is filed, which ones are at issue, right? But it doesn't change the right that you, or the obligation, the right they had to payment and the obligation that the insurer has to pay it.
Well, but it certainly, it alters the obligation, because what we're calling the obligation, this obligation to issue a formal denial, that in no way, shape, or form existed then. More generically, there is a reason to deny a claim if you are not going to pay it, or, but again, what form that denial would be, whether to continue looking at it. Maybe they've expressed a view that there's other insurance that might apply to this. We're looking into it more. Time goes by. I'm not going to try and excuse any, delay on the part of the insurer and try and justify it if it goes on for a long time. But the fact is, there was no legal consequence in the form of altering that 1 year back limitation on the benefits that can be recovered. And again, that is a substantive matter that the legislature has decided for all sorts of public policy reasons. The whole No-Fault Act is a big bundle of compromises of policy considerations. And that 1 year back is part of that whole balancing act.
So tell me why we shouldn't consider, I get the argument that it took 12 years to do so. Why shouldn't we look at what the law was before de Villers and the statute that says we're going back to that? I mean, basically, it doesn't explicitly say that. I understand that. But now, under this statutory provision, DeVillers is irrelevant, right? Why shouldn't we look at that as the legislature intending to fix the DeVillers problem?
The reason why, Your Honor, and I'd take issue with, I think, a comment earlier that DeVillers was wrong, or that it is now overruled legislatively. That's not true. There's nothing that DeVillers said that is wrong. And there's no suggestion in this legislation that DeVillers misinterpreted the prior statute, and now we have to have an amendment to implement what was intended originally, but DeVillers got wrong. That's not what happened. You have the clear 1 year back means 1 year back statute. Then Lewis comes along and does some legislative-like doctoring of that statute. DeVillers makes clear that this court doesn't have the authority to do that type of thing. And the statute is clear, it is what it is. Now, the statute now comes out and makes a legislative substantive change to that rule. It does not suggest that DeVillers misinterpreted the original statute.
But does it
Nobody
have to?
contends that
Does it
that
have
original
to, as long
statute
as
had
it just
tolling.
changes it?
Pardon me?
I mean, does it have to say we think DeVillers was wrong? I mean, whether or not DeVillers is overruled or not isn't really that relevant, I don't think, to us. Like, it said before there was a tolling provision, and it was applied very similarly to how it's been now spelled out in the statute. Does it matter that the legislature thinks that DeVillers was wrong or not, but they think that now that there should be a tolling provision?
Well,
Isn't that
that's
what's
the way to look at
relevant
it.
to cure what wasn't in existence in the statute before?
I think the legislature did decide that, as it was currently made up, it decided that that's a good public policy rule to have. The court had previously had that under the Lewis case, but in a sense, although it took time before this was called out, it was an illegitimate act. But now the legislature says, DeVillers is right. That was not proper. The statute doesn't have any kind of tolling. But now we think it is a good idea. Let's have a tolling provision. And it went into effect June 11, 2019. I don't think you can, it's not remedial or curative in the sense that you would need it to be in order to apply it retroactively, because it's new public policy first put into place on June 11, 2019. And so, also, I take issue with the notion that the four LaFontaine-Buell factors or considerations lean in favor of applying this retroactively. I think it's quite the opposite. The first of the four, I think, is important and should not be overlooked, and that is the question of whether there's any hint in the statute that reflects an intent on the legislature for it to apply retroactively. And obviously there is no such hint of any sort. Quite the opposite. This court has said that when the legislation is declared to take immediate effect on that date, that's some evidence that they want it to start then and go forward and not go back, not apply retroactively. Another one is one that you pointed out, Justice Kavanaugh, that if it affects a prior transaction and imposes new significance to an act that at the time there was no such significance, that's a vote against applying it retroactively.
But that was, in McLean, that was a right that had accrued and expired prior to the statute going into effect, right? And so maybe that's an argument for a different set of claims than what we're dealing with here, where they accrue, but that 1 year that attached to them, maybe I'm the only one who thinks of it that way, but like, that it was imbued with this 1 year statute of limitations, 1 year back, quality. When it was incurred, that hadn't expired by the time that then they still had a year to file suit and try and recapture that. I mean, the difference between that and McLean. McLean, the claims had arisen accrued, the statute had expired before this new statute that was being argued should be able to reach back and extend their
So
accrual.
is this pertaining to your question about how the case would apply, how this court might address it if you had facts where the 1 year had already expired before the amendment?
Right.
Yeah, well, I know that by differentiating this case from that case, that set of facts, my opponent would suggest that since their claim was kind of, quote, still viable, the 1 year had not expired by the time the statute was amended, they get the benefit of the tolling. And they would say that that's because the operative date is when you file suit, not when the claim is incurred. Well, two things about that. First of all, we know that the claim accrues in a no-fault case by statutory edict, that when the expense is incurred, that's when the claim for no-fault benefits accrues. So we know that, and intimately connected to that is the 1 year back rule in 3145, which likewise all is centered around the date on which a claim is an expense is incurred.
Well,
And-
but the statute says with respect to the 1 year statute of limitations, it's a year from when it's incurred, but the 1 year back is from the date of commencement of suit.
Well, at one end of the spectrum, but what drops off, if they're talking about any claim, any expense that is incurred, you look at that date, that's, when is the treatment rendered? That date, that's the expense which is incurred. And now, 1 year later, subject to some tolling rule, that drops off because that's the trigger point. Your time, you can look at it from going backwards from when you file the lawsuit or going forward from the date that the expense is incurred. And, absent tolling, the time starts running. And then 1 year later, once you pass the 1 year, that expense is dropped off from potential recovery when the lawsuit is filed. But I got to get this point. It was just in my head. But so my question would be, if they have an expense, I see my time just ran out, but I'll finish this point. You have the expense. They have a year to file suit in order to recover it. They go past that, but in the meantime, the statute was amended, so this tolling provision emerges. They say, oh, hey, now we've got the benefit of tolling. They would like to say, it's not retroactive. We can apply that now when we file suit. It's post-amendment. We're all set. But pray tell, what are they applying that tolling provision to? They're applying it to this expense that at the time when the 1 year clock starts running and when it would I would ask, when did tolling start? Tolling would start when they submit their bill. They submitted it shortly after the treatment in May of 2019. And they want to say that their tolling started then. But there was no such thing as tolling at that point. How can you say it was not being applied retroactively to something that didn't exist at the time? So that would be my closing comment. And my actual closing comment would say that now we're 5 years removed from that amendment, fewer and fewer cases or incidents of these old claims are going to be governed by any decision the court makes here. The Court of Appeals have been unanimous on construing it the way we've advocated. I think it's one you should very strongly consider simply denying leave to appeal.
Thank you. Thank you
Thank you.
both. The case will be submitted.